话筒连接成功。
an accident at the campus. And he went back home to surgery. You won't be able to see him for 2 weeks. Or 1 week or 2. Good morning, everyone. Nice to meet you again. Today, we are going to explore the remaining part of the Chapter 4, the WTO dispute settlement. As time is running short, let's just jump right in the content. As usual, I'd like to do a brief review of what we've learned last week. But this week, I'll just give you one basic question. The question is like this. Listen carefully. What are the two tasks or objects or purposes of the WTO dispute settlement? For example, there is a dispute. Then there will be WTO dispute settlement, the proceedings. Then my question is, what are the two tasks or objects or purposes of the WTO dispute settlement? Number one is, okay, would you like to have a try?
Okay. The prompt settlement of disputes between WTO members concerning their respective rights and obligations under WTO law, and to provide security and predictability to the multilateral trading system.
Okay, very good. Thank you very much. Multilateral, okay? Good. He's right. The two basic tasks or objects are, number one, to preserve the rights and obligations of members under the covered agreements. Number two, to clarify the existing provisions of those agreements. Okay. Now, let's jump to today's content. Look at this slide. Okay, look at this slide. Last week, we talked about judicial activism. Judicial activism means legislation by judges. In the context of the WTO dispute settlement, the judges are panelists, the panel, and the members of the AB, the members of the appellate body. They are judges, which means the panelists and the members of the appellate body are not allowed to legislate or to make law because the SU does not allow judicial activism. It has nothing to do with the discretion of the judges. No. Okay. Now look at here. I remember we talked about the VCLT, right? The Vienna Convention on the Law of Treaties. Okay, and I mentioned specifically 2 articles. One is Article 31, the other is Article 32. These 2 provisions or these 2 articles are about the interpretation of international law. Article 31 relates to the general rule of interpretation, while Article 32 is about the supplementary rule of interpretation. Okay, question. What is the legal status of these 2 articles? I mean, are they customary international law or treaties or general principles of law or judicial decisions or the teachings of the most highly published, the most highly, how to say the word? The teachings of the publicists. Which one? What is the legal status of these 2 articles? First, what? Look, is this a treaty or a convention? Yes, Vienna Convention. So of course, they belong to treaties, provisions of a treaty, right? That's correct. But pay attention. These 2 articles also have a legal status of customary international law. Don't you think it a little bit strange? Can this kind of phenomenon happen? An article is both a customary international law and a treaty? The answer is yes. Then I just find it strange. How does this happen? Well, the VCLT is just a codification. Just a codification of customary international law. That's why. Okay, got it? Then let's come to next slide. Look here. Article 32 also attained the same status of a rule of customary international law. Both of them belong to customary international law. Good. Okay. Look at this sentence. This sentence is rather important. It's the content of Article 31 of VCLT. I will invite someone to read it for us. Okay. 陈依婷. A treaty shall be interpreted. from here on.
A treaty should be interpreted in good faith in accordance with the customary meaning to be given to the terms of the treaty in their context and in the light of the object and purpose.
Okay. Thank you. Please sit. Okay. Look, there's one thing I'd like to stress. First is about TH. TH together pronounces as th, 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 with your tongue bitten by your teeth. Okay. Then another one is that. Okay. And here, in light of the object and purpose, okay? This sentence is rather important. You need to memorize it or recite it. Okay. Now let's analyze this sentence literally, which means word by word. How many elements are there in this sentence in the process of interpreting a provision of a treaty? Let's count, okay? First is in good faith. In good faith. When you are interpreting a provision, the judge must be in good faith, which means being honest. Second element is ordinary meaning. Ordinary meaning. Its usual meaning. Ordinary meaning. Element number 3 is the terms of the treaty. The terms of the treaty. Let me check whether it's right or not. Yeah. Number 1, number 2, number 3 is the terms of the treaty. Number 4 is look, the terms of the treaty also mean the text. Text. And number 5 is about object and purpose. I mean the objective. There are 5 elements concerned in the process of interpreting a provision of a treaty. Okay? Good. But my next question is, are these 5 elements hierarchical? Hierarchical means different layers. Yes or no? No. They are equal in terms of their legal status. There is no hierarchical order for these 5 elements. Okay. Okay. These elements constitute one holistic rule of interpretation and not a sequence of separate tests to be applied in a hierarchical order. Okay, let's move on to the next page. This one, Article 32 of the VCLT, the supplementary rule of interpretation. Question is, what's the aim of supplementary means of interpretation? What's the aim? Look, the words in red. Number one, confirm the meaning. Number two, determine the meaning. That's the aim of Article 32. Next question. Under what circumstances does an interpreter need to resort to Article 32 of VCLT? When do we need Article 32? When? Yes, can you find the answer in the PPT itself? Okay.
When the interpretation according to Article 31 leaves the meaning ambiguous or obscure.
Yeah. And
or B leads to a result which is manifestly absurd or unreasonable.
good, very good. So under two circumstances, we need to resort to Article 32. When, look here, the word when the interpretation according to Article 31, which means the general rule of interpretation, leaves the meaning ambiguous or obscure, not clear, ambiguous or obscure. Or Article 31 leads to a result which is manifestly, also means clearly, absurd or unreasonable. Under these two circumstances, the interpreter can resort to Article 32. Okay, good. Okay, then let's move on to next page. The subsection F, remedies for breach. According to this slide or this page, I've got several questions for you to think. Question number one, under which two circumstances are temporary remedies available? Temporary remedies are available. Look here. Two temporary remedies which can be applied here, pending the withdrawal of the WTO inconsistent measure. And number two is in the event that the recommendations and rulings are not implemented within a reasonable period of time. Here, the second one. The temporary measures are also available in the event that. That's question number one. Question number two, how to bring a measure into conformity with the WTO law. How to. Look here. Bring the measures into conformity with the WTO law. How? I'll give you an example. For example, right now, the US, United States, is increasing its tariff rates globally, which means against almost all the countries in the world. That is a kind of unilateral action. This action, unilateral action, is obviously in violation of WTO law. This kind of measure is WTO inconsistent. WTO inconsistent, this kind of action. Then, how to change this situation? How to change this situation? For example, the United States was sued in the WTO and it lost the case. Then this kind of measure, the unilateral action, can be, first one, withdrawn, or second, modified. If the United States lost the case, its measure will have to be withdrawn or modified. Only in that way, we can bring the measure into conformity with the WTO law. Okay? Okay, next question. How can the reasonable period of time for implementation be ascertained? Two methods. Reasonable period of time for implementation. Here, the answer lies here. The reasonable period of time for implementation may be, number one, agreed on by the parties to the dispute. Number two, determined through binding arbitration at the request of either party. Here, the arbitration appears again. You still remember the ADRs? Yes? Yes. The arbitration appears in two cases or scenarios. Number one is here. Determine the reasonable period of time of implementation. What's the other case? Arbitration. You still remember that? There are two scenarios. Okay, we'll leave that question until after class. At this point, you only need to know how can the reasonable period of time for implementation be ascertained. There are two methods. Okay. Good. Next page. Look at this sentence. Look at this sentence. The obligation to implement starts at the moment of the adoption of the report by the DSB and not at the moment of the arbitrator's award, setting the reasonable period of time. So the question is, when does the reasonable period of time for implementation start? It starts at the moment of the adoption of the report by the DSB and not at the moment of the arbitrator's award, setting the reasonable period of time. Okay. Let's move on to next point. In almost all cases, the responding party implements the recommendations and rulings adopted by the DSB. The compliance rate is as high as 90%. Is it high or low? 90%, which means 9 out of 10 cases or rulings or recommendations will be implemented. Is that high or low? Rather high, right? Good. Okay, next question for this slide is about compensation. What are the two characteristics of compensation under the WTO law? One is voluntary. The other is forward-looking. These two are the characteristics of compensation in WTO. Okay. Voluntary means who has the initiative? Who has the initiative? Look, voluntary, i.e., reads that is, or namely, the complainant is free to accept or reject compensation. So who has the initiative? The complainant. The complainant. Okay, good. Let's move on to the next part. Retaliation. I think this point we have mentioned in the course of the general theory on international economic law. What is the sequence of retaliation? What is the sequence? Look here. Sequence of retaliation. Retaliation arises first, second, in the same sector under the same agreement. Second, in another sector under the same agreement. Last, under another covered agreement. I'll give you an example. For example, this is GATT, and here is GATT. We've got so many specific agreements. SCM, Subsidies and Countervailing Measures Agreement. This is just one of the specific agreements. First, for example, the measure is about SCM. Then the retaliation first appears under the SCM agreement. This is the first step. If this cannot achieve a satisfactory end, then we will go to which agreement? Another sector under the same agreement. The same agreement means GATT. We will turn to maybe another, for example, TFA. We will turn to TFA. And step 3 would be if nothing in GATT, then we can go to GATT. So this is step 1, step 2, step 3. And the latter 2 together is referred to cross retaliation. Okay, we'll move on. On this slide, there is also a very, very important point for you to highlight. Okay. It's also related to the relationship between the WTO law and the general public international law. We already mentioned one. It's about the legal status of Article 31 and 32. Here, there is another issue about the relationship between the WTO law and the general public international law. It's about here. Look at this paragraph. The question is, under customary international law, what are the legal consequences of a breach of an international obligation? The answer is not here. It's in the previous slide, I suppose. Here, the answer lies here. 1, 2, 3, 4. Okay. The next question. Does customary international law on state responsibility apply to a breach of WTO law? I'll repeat the question again. Does customary international law on state responsibility apply to a breach of WTO law? Let's come back to the example again. The U.S. unilateral action violated the WTO law, and there is a ruling made. At this point, how to punish the United States? We punish the United States according to the WTO law or the public international law. Public international law, you know, we have this one. We have something about international responsibility of a state, right? Have you ever heard of that convention? The draft convention on states' responsibility? Never? Actually, in public international law, there is this draft articles on state responsibility. Draft articles on state responsibility. It's kind of a convention, something like a convention, okay? But it belongs to public international law. Question is, how to punish the United States? We punished the United States according to this convention or according to the DSU? Which one? Which one? Why? Why we would turn to DSU to punish the United States? Why? These two. Because DSU is WTO law, right? It is a lex specialis. What does lex specialis mean? Yes, special rules, special law. Then the question becomes easy. The question becomes, when there is a conflict between general rules and the special rules, which rules prevail? Which rules? Good, very good. The special rules prevail. So we will punish the United States according to DSU instead of the draft articles on state responsibility. That's easy. Easy peasy, right? Okay, good. Next, we'll move on to slide 86. There is a question. Which key decisions are subject to negative consensus? Which key decisions are subject to negative consensus? In WTO dispute settlement, for some key decisions, 1, 2, 3, they are subject to negative consensus requirement, or we say reverse consensus. Reverse means negative. In Chinese, we call it, how to translate it? Reverse or negative consensus.
反向
反向 and what?
负面
Good, very good. 反向一致 or 反向协商一致. But there are two ways to express this. Reverse consensus, correct. Or negative consensus, also correct. What does that mean? What does negative consensus mean? I'll give you the answer, okay. What does negative consensus mean? Listen carefully. The DSB is deemed to have taken a decision unless there is a consensus among WTO members not to take that decision. The decision making by the DSB on these matters is automatic and a matter of course. Automatic and a matter of course. As long as there is one vote in favor of the decision will be made, right? So we can say that this kind of decision making is automatic and a matter of course. What does a matter of course mean? It's a matter of course. In Chinese, we call it a 走过场, right? A matter of course, yes. And it's automatic. The decision will certainly be made, yeah, right? Yes, because it's a negative consensus. Good. Now let's move on to subsection B, panels. Panels. And the first issue is about the establishment of panels. How to establish a panel. We need one instrument. This instrument is important. It's called the request for the establishment of a panel. Look at the quotation marks. The quotation marks. The request for the establishment of a panel. It's so long. So we gave him a short name. It's called a panel request. Panel request. Next week, I will ask you, what is a panel request? If you think about it, panel request. Panel request is about the panel's request, yes or no? No, the request is not made by the panel. It's about a request of establishing a panel, right? So it will cause misunderstanding. So you better recite this. Sorry, memorize this. Pay more attention. Panel request. Then, what are the two essential purposes of a panel request? Two essential purposes. Number one, number two. The answer is evident, and I will not repeat it anymore. But you need to know that because the words are highlighted in red. Okay, now let's take a break of 5 minutes. We will come back later.